is the observation. But earlier judgments and later judgments subsequent to that 2020, my lord, I have been able to lay my hands upon it. Straight away, I can invite my lord's kind attention to more than one judgment on the points. Before I take your lordship to those judgments, my lord, let me submit your lordship one thing. Please do not mistake me that I am going to the fundamentals. Please do not mistake me.
No, that's all right. So what?
Lord, your lordship is certainly aware of all these things.
Sir,
But,
no, sir, that's not there. Sometimes we may also fumble on fundamentals. Yes.
my lord, the court would take cognizance under section 190. It leaves no note. Your lordship has ruled in several cases. If it is a private complaint, my lord, it would be under 190, 1A. Well, if it is a police report under 190, 1B. If it is on any other information which the court would get, it would be under 190, 1C. Well, now in this present case, we are only concerned with the court taking cognizance of an offence under section 190, 1B because it is on the basis of a police report it has been given. Well, may I just request your lordship to just refresh my lord's memory. Have a look at section 2R of this. In fact, your lordship has referred to it in the umpteen number of cases. Well, have a look at section 2R first.
Yes.
Well, what is police report?
Yeah.
Well, 190, 1B refers to the court taking cognizance on a police report.
Yes.
Have a look at police report as defined under section 2R of the CRPC. Police report means a report forwarded by a police officer to a magistrate under subsection 2 of section 173.
Yes.
It is on the basis of this report, my lord, the trial court would take cognizance of the offence, whatever may be the offence. We are not on that issue now. Well, now may I request your lordship to kindly go to 173 subclause 2. Have a look at 173 subclause 2. Well, 173 subclause 2 would say every investigation and the investigation, we are not concerned with that, 376 and all that. Now subclause 2. As soon as it is completed, well, the report of police officer and completion of investigation. This is a police report that is defined under section 2R, 173 subclause 2. As soon as it is completed, the officer in charge of the police station shall forward to a magistrate empowered to take cognizance of the offence on a police report, a report in the form prescribed by the state government stating, number one, the names of the parties, the nature of information, the names of persons who appear to be acquainted with the circumstances of the case, whether the offence appears to have been committed and if so by whom, whether the accused has been arrested, whether he has been released on his bond, whether he has been forwarded in custody, whether they report medical examination, etc. Well, the police report as mandated under section 173(2) should contain all these things, including the statements of witnesses who are acquainted with the facts of the case. Well, it is on the basis of the police report that is found under section 173(2) of the court, the magistrate would take cognizance. So for the purpose of taking cognizance, indeed, the magistrate is bound to advert to the evidence which the investigator had collected, which are enumerated under section 173(2) of the CRPC, without which he could not have taken cognizance of the offence at all. 161 statement or the statement that is recorded under section 161, statement that is recorded under section 164, would form part of the police report as defined under 2R for the purpose of taking cognizance of the offence would be my first respectful submission. Well, without which he can't look into it at all. Without which he can't make out whether an offence has been made out or not. Well, then, kindly imagine the situation, Miller. He files a charge sheet. Well, a charge sheet contains the statements of witnesses, be it under 161, be it under 164, in addition to other documents which you would be collecting. Well, in order to seek the benefit of an order of discharge, or the prosecution to seek the benefit of an order directing framing of charges against the accused, but he has got to advert to the police report and the record of the case, be it under section 227 or under section 239. 239 refers to the cases triable by a magistrate, and 227 refers to the cases triable by the Court of Sessions. What needs to be seen for the purpose of either framing of charges or for the purpose of passing an order of discharge, my lord, is the record of the case, which includes all these things, a police report. My lord, this 161 forms part of the police report. My lord, the magistrate could look into it for the purpose of proceeding to frame a charge or passing an order of discharge. If the Sessions Court is entitled to look into it, can we say or can we contend, can the prosecution contend that this honorable court in exercise of its jurisdiction under 482 cannot look into the police report, which includes the statements of witnesses recorded under section 161 of the CRPC? Well, it is only on the basis of the statements of witnesses recorded, it would become possible for the investigator to formulate an opinion with regard to the commission of the offense or not, so that the accused is sent before the court to take his trial in the case. Well, and now, may I invite my lord's kind attention to the judgment of the Supreme Court in 1983 Supreme Court cases 152 paragraph. Our ಕೊಟ್ಟಿದ್ದೀರಾ copy? Professor, I have received the copy. ಕೊಡಿ ಅವರು ಕೊಡಿ. May I request your lordship to kindly turn to paragraph 5, which your lordship would find at page 195. This was under Essential Commodities Act.
Ink page 195.
Ink page 195. Well, it commences at 192. Kindly go to ink page 195, paragraph 5. Well, since this is an important legal issue,
Yes.
which my lord wanted some clarification, that is why, my lord, I am dealing with it at
Yes.
length. Code of Criminal Procedure 1973. Every offence punishable under the act shall be cognizable, which would imply that an officer in charge of a police station, on receipt of the information of such cognizable offence, may, without the order of a magistrate, investigate into the offence according to the procedure prescribed in chapter 12 of the code. On completion of investigation, it commences from section 154, 155, 156 and all that. On completion of the investigation, the police officer shall submit a report to the magistrate empowered to take cognizance of the offence on a police report. The report has to be in the prescribed form, and the details to be mentioned in the report are specified in section 173(2). While submitting this report in connection with the offence to which section 170 of the code applies, meaning thereby that a case in which such investigating officer has found sufficient evidence for a trial to be held by the court, it is incumbent upon such officer to forward to the magistrate, along with his report, A, all documents or relevant extracts thereof, and with the prosecution proposes to relay, other than those already sent to the magistrate during investigation, and B, mark this, my lord, the statements recorded under section 161 of all the persons whom the prosecution proposes to examine as the witnesses. During the course of the investigation forms part of the police report. Now, may I request your lordship to kindly turn to paragraph 9 at ink page 198. My lord gets it?
Yes.
Section 173(2)(1) provides that on completion of the investigation, the police officer investigating a cognizable offence shall submit a report in the form prescribed by the state government, stating therein the names of the parties, the nature of information, the names of persons who appear to be acquainted with the circumstances of the case. That is the statements of witnesses under 161. Whether any offence appears to have been committed, and if so, by whom, whether the accused has been arrested, whether he has been released on his bond, and if so, whether with what sureties, whether he has been forwarded in custody under section 170, subsection 5, section 173, makes it obligatory or relevant to extract thereof, and with the prosecution proposes to delay and, my lord, mark this, the statements recorded under section 161 of all the persons whom the prosecution proposes to examine as witnesses at the trial. Well, this forms part of the report of the investigation as found under section 191B as well as under section 173 to be managed. Now kindly read the next paragraph, my lord. Section 173(2) thus provides the report did contain the name of the accused and the nature of the offense. In fact, section 170 provides that if upon an investigation into chapter 12 it appears to the officer in charge of the police station that there is sufficient evidence or reasonable ground to proceed against the accused, such officer shall forward the accused in custody to a magistrate empowered to take cognizance of the offense upon a police report. If the accused is on bail, that fact will be notified in the final report submitted under section 173(2). Therefore, the statutory requirement of the report under section 173(2) would be complied with if the various details therein prescribed are included in the report. This report is an intimation to the magistrate that upon investigation into a cognizable offense, the investigating officer has been able to procure sufficient evidence for the court to inquire into the offense and necessary information is being sent to the court. In fact, the report under section 179(2) purports to be an opinion of the investigating officer that as far as he is concerned, he has been able to procure sufficient evidence for trial of the accused by the court, and when he states in the report that not only the names of the accused, but names of witnesses, the nature of offense, and a request that the case be tried, there is compliance with section 173(2). The report as envisaged by section 173(2) has to be accompanied as required with subsection 5 by all the documents and statements of witnesses therein mentioned. The result of the opinion which he formulates is the one that your lordship would find in column number 17 of the pro forma charge sheet. That opinion, my lord, is based on the evidence which he would have collected during the course of the investigation of the crime. For this court to find out whether the opinion which he has given as found in column number 17 of the pro forma charge sheet, is it correct? Is it wrong? Is it right? Is it acceptable or not? What needs to be seen is the evidence which he has collected. Well, now let us go to the next sentence, my lord. One cannot divorce the details which the report must contain as required by subsection 5 from its accomplishments which are required to be submitted into subsection 5. The whole of it is submitted as a report to the court. Well, I think the rest of the things we can skip. This would be my first submission. Well, now may I request your lordship to kindly turn to the case in 1954, volume 2, Supreme Court cases 934, which your lordship would get at ink page 211. May I request your lordship to kindly turn to paragraph 8, my lord, at page 227. My lord gets it.
Yes.
Thus, under the code, investigation comes ascertainment of facts and circumstances of the case, discovery and arrest of the suspected offender, collection of evidence relating to the commission of the offense, which may consist of the examination of various persons, including the accused, and the reduction of their statements into writing if the officer thinks fit. Well, that is the only thing that is relevant for the purpose of this case. Well, therefore, my respectful submission to your lordship is a combined reading of the provisions of section 2R, 173 subclause 2, and the law laid down by the apex court in more than one judgment, would give us an indication that the statements The investigator during the course of the investigation of the crime should collect evidence. He would be collecting evidence by recording the statements of witnesses who are acquainted with the facts of the case. And those statements that are recorded, be it under 161 or under 164 of the CRPC, would form part of the record of the case in as much as it becomes part of the final report which you would be filing. And the opinion which you would be arriving at is based on the evidence which you would have collected. And that is the one that is found under column number 17. And that opinion is put into test. But your lordship would be examining whether that opinion is right or wrong on the basis of the evidence which he had collected. Therefore, my lord, I am required to invite my lord's kind attention to the evidence which the investigator has collected, since I had sought for the quashing of the charge sheet in this case.
Yes.
What do you Cyber Gutta Wayne's case, my lord.
Conclusion can be ensured.
That's what I submitted. Yes, no, Pera? Well, and ultimately, I'm sorry.
Yes, sir.
Well, and ultimately, my lord, your lordship could certainly eschew the opinion of the investigator in the event that the investigator has come to a wrong conclusion or a wrong opinion after examining the evidence which he has collected. Well, that is what the Supreme Court has said in Bain's case. Well, your lordship may kindly turn to page 202, ink page 202. This is in 1980, volume 4, Supreme Court cases, 631. May I request your lordship to kindly turn to ink page 200, paragraph 6. It is
Yes.
seen from the provisions to which we have referred to in the preceding paragraph that on receipt of a complaint, the magistrate has several courses open to him. He may take cognizance of the offence and proceed to record the statement. So the complainant and the witnesses present under section 200.